All right, we're live.
Okay, cool. Okay. Hello everyone, and welcome to the webinar. First, let me introduce myself. My name is Geoffrey Keunen, Senior Manager at Cranium, and I will be the moderator of this webinar. During this webinar, Bart van Buitenen, our Director Expertise, with more than 10 years of experience in privacy and IT security, will provide you with more insights with regard to the supplementary technical measures in alignment with Schrems II. If you have any questions or remarks during the webinar, please do not hesitate to reach out to us. You can put your questions into the chat box. After the presentation of Bart, we will try to answer a few questions. The other questions will be answered via email. So, Bart, the floor is yours.
Thanks very much, Geoffrey. I see that we have plenty of the required attendees present now, so we'll definitely kick it off immediately. So, also from my side, welcome to the webinar on the supplementary measures from Schrems II, a technical perspective. Just to set the scene a tiny bit, although I assume that most people who are present in this webinar will know the background of Schrems II, but to summarize it in the slightest, Schrems II basically meant that we can no longer rely on Privacy Shield when we transfer personal data to the US, because US legislation contains a number of aspects that are not compatible with our law. Now, Privacy Shield is a framework where if we can't trust, put it that way, American legislation, well, then the whole framework doesn't work anymore. So it was invalidated. We also have our standard contractual clauses, which are more of a contract, which are more flexible, and which, if you have additional measures that you can take, may still be applicable. And that's the scope of this webinar, where the European Data Protection Board has published a number of those supplementary measures that you can take. And what I've seen in other webinars, in other information all over the internet, is that is mostly focused on those organizational measures, contractual measures that you can take, and not so much on technical measures. And that's something that I like to dive into a bit. So what I hope you'll take away from this webinar is which measures might we be able to take, which examples have we seen in practice. We take a look at a number of use cases that we've seen as well. Which measures can I take that hopefully, because you never know for sure until it's actually in front of a court or a data protection authority, can we take that will provide sufficient measures. To give a bit of a spoiler at the beginning of the presentation, basically the summary, what we have seen in the European Data Protection Board guidance, which was a bit sobering, is basically that they said, we in our guidance described a whole bunch of use cases. The most common use cases, well, in our opinion, as a European Data Protection Board, we can't think of any measures you can take that will make these fully compliant. I think about the classical use case of Microsoft OneDrive, Google Cloud Drive, the typical American big tech solutions that most of us use almost every day. Well, of course, that's what the European Data Protection Board should say if they can't think of anything, but that leaves us as a DPO, as a privacy professional, with basically what we already see in GDPR, which is one of the cornerstones, is the risk-based approach. We will need to take a look at what do we have in front of us, what kind of transfer is this, what kind of data is it, focus on accountability, be able to demonstrate what we've done, which measures we've taken, and then do the best we can do in that way. And whenever a case will be taken to court or will be assessed by a DPA, we will need to show what we've done and demonstrate that we have taken the additional measures, have provided additional safeguards to protect personal data. So in the end, that's what this presentation is about. How have we divided it up? We'll be taking a look at basically supplementary measures in theory and supplementary measures in practice. The theory is the European Data Protection Board guidance. We'll go over the different use cases that they presented in their guidance. We'll take a look at in what way could we apply them. What did they describe regarding the measures you should take in each use case. We take a quick look at the draft standard contractual clauses, not the entire document, but focusing specifically on the security measures, additional safeguards that they have included in the draft SCCs. We have taken the version which already included the European Data Protection Board and EDPS, the European Data Protection Supervisor, their joint opinion. So take a look at what did they mention, what examples do they give, what can we take from the SCCs, the draft ones that we have now. And then finally, we take a look again at some practical examples. So we take a look at the case that was in front of the Conseil d'État, which involved AWS, the Amazon Web Services provider, in transferring vaccine-related data, where the Conseil d'État said this transfer seems okay. And we take a look at two other cases where we had the MailChimp case, quite recent, I think it was about a month ago, where the Bavarian Data Protection Authority ordered an organization to stop using MailChimp. And we take a look at a really recent case. I included it pretty much at the last minute. I saw it today from Portugal, where the Portuguese Bureau of Statistical Affairs, or whatever the official name should be, used an American provider, Cloudflare, in one of their processing activities, and they were summoned to cease that transfer within 12 hours by the Portuguese Data Protection Authority. So one case where we found enough supplementary measures, and two where they didn't, and we'll take a look at all three of them and see what we can learn there. I also take a look at more from our practical side as DPO, from our project at Cranium, which measures have we seen implemented, which according to us feel like they are sufficient. And then finally, I'll take a short look at an example that I received in my role as DPO from a US-based processor, where I felt, again, nothing's perfect in this context, but that I felt that was a pretty good reply. One of the best that I've seen from all the different providers that I asked as a DPO, what have you done regarding Schrems II? And so basically that's the overview of the webinar, all the things that we'll be seeing this afternoon. Diving into it straight away. So we have the more theoretical approach from the European Data Protection Board guidance. As I mentioned, they talk about supplementary measures which can be contractual, again, things that you put in the contract with your processor, technical and organizational. And organizational might be other measures like specific policies that you decide on, where they mention, well, contractual, organizational, that's all fine and dandy, but in the end, probably only those two won't suffice because, well, contracts can be broken, organizational measures, policies can be ignored. Technical measures, on the other hand, can have a very strong safeguard because they can be avoided if they are correctly applied. So again, that's what we're focusing on right now, those technical measures that were mentioned in the EDPB guidance. A short disclaimer, currently, even though they were already from last year, those guidelines are still in public consultation. As most of you have seen, between their first public consultation guidance and the final version, not that much changes most of the times, but a small disclaimer, they are still in public consultation right now. The EDPB provided their own introduction. How should you situate these supplementary measures, our guidance? You've seen they had, I think it was a 6-step approach to looking at international data transfers. And the 4th step is, if you've done the analysis of which parties are involved, where are we sending the data, which data is involved, well, adopt supplementary measures. And that's why they say that's where our guidance sits. We try to give you those supplementary measures. They also mention, well, the list that we have here, the things, the use cases that we describe, this is not an exhaustive list. You can do other things, and as long as you can explain, account for the fact that they should be sufficient, that might work. So the EDPB tried their best, but they claim themselves as well. There are other measures that you might be taking, and depending on the case-by-case analysis that you do, those measures might be sufficient. And that's what they emphasize as well. It's up to you to do the case-by-case analysis and to make sure that in whatever assessment you do, for example, the classic transfer impact assessment, you address the specific deficiencies that you've seen in your processing activity in your specific case. The use cases that they specifically mention in their guidance, we take a look at the first one. It is about storing backups in a third country. So obviously you can have backups for your data and store them in the EU, which isn't a problem, at least for this international transfer context. You can also use an external provider which is located outside of the EU, and in that case you will be using or storing data in a third country for backup purposes. In their guidance, the EDPB goes over a number of measures you should be taking. Strong encryption before transmission, making sure that the data isn't accessible. When you use encryption, The encryption algorithm should be state-of-the-art. It shouldn't be crackable. The strength of the encryption should also be related. You should keep in mind how long should the data be confidential. In other words, encryption algorithms, they often rely on how much computational power do you have, how many strong computers might an attacker have to crack the encryption. Well, talk about quantum computers, which are in the media quite a bit. In the next 10, 20 years, maybe they will be mainstream. And the encryption that we have now may not be sufficient for the future. So that's something that they take into account and say, well, if you do use encryption, make sure that it's a sufficiently long-term proof. It should be flawlessly implemented. Perhaps some certification should be there. The keys, so basically the password that you use to encrypt and decrypt, should be reliably managed. And in the end, that key should only be available to the exporter, so the organization sending the data to a third country. If we wrap that up into the bottom line, it basically means if we encrypt the backups, so if we make sure that they can be accessed by the external party before we send them to a third country, well, then that's fine. We can use a third country for backup storage. Their second use case, they talk about pseudonymization. We take the data set that we have, we transfer it, and for example, medical, scientific research, we transfer it to a third country. Again, going through the different measures that they proposed, they're all about pseudonymizing the data before we send it to the third country, meaning if someone in the third country would have access to that data, they can never identify an individual. That's the basic principle of pseudonymization. They go through a number of things which are logical when we talk about pseudonymization. So there shouldn't be any additional information. If you pseudonymized data, there will always be a set of information that will help you re-identify the pseudonymized set. Well, this additional information should, of course, not be available to anyone else but the data exporter. This additional information should be sufficiently secured. So technical organizational measures to secure the additional information. Make sure that you've analyzed that you couldn't find this additional information anywhere else in the world. And so, again, summarizing it to the bottom line, if we want to send data to a third country in the context, for example, of research, well, if we anonymize that data before sending it, then GDPR doesn't apply. And then, of course, we don't have an issue. So as long as for the recipient in the third country, that data is anonymous, because we, from our side as controller, pseudonymized it, then sending the data is fine as well. Use case number 2, going to the third one. We have a situation, as they describe it, where we don't actually store the data in a third country, but while sending the data to its final destination, we transfer through a third country. The case that we look at in a second from Portugal is pretty much where this comes into context, where you have the data being sent through a third-party provider who then sends it back to the final recipient in the EU. Basically, the same here applies as that we saw in the first use case, where data should be sufficiently encrypted. They still mention the state-of-the-art encryption, but now it's more related to the transport, not the encryption where the data will rest, but the encryption in transport. Encryption should be trustworthy. It should be the PKI is the public key infrastructure, so the whole tool set that you've set up to enable the encryption, to be able to apply it. The keys, again, the password should be reliably managed. So the basic same things that we saw in the first use case. If you make sure that trusted provider or yourself have encrypted the data in such a way that the party in between, where you're sending the data through, can't access it, well, then again, we have a nice use case where you can, in fact, with the additional safeguards that you've implemented, send data to a third country. One of the perhaps more applicable practical use cases where I can see, well, this is something that I can imagine in practice, more specifically, is their fourth use case, where they say, well, we have a data importer, so the recipient of the data in a third country, and they have their professional secrecy. They have a provision in the legislation of the third country which prevents any other party taking knowledge of the information, of the data that was sent. So classic use cases might be a doctor under their professional secrecy for medical care, legal services, a lawyer also has professional secrecy. They then go over a number of things which might make, which is common sense, but of course it's logical that in their guidance they specify it in this way. So the importer is indeed exempt from providing access because of his professional secrecy. Any information that might be used to get access to that information, for example, imagine that the doctor or lawyer in question would be forced to give up the password. Well, that should also be covered by the professional secrecy. When the data is being sent, it should be encrypted. When the data is decrypted, well, it should only be available to the importer, so the doctor or the lawyer. So again, the classic things that you might expect. Make sure that if you send it to someone who can take note of the data, can process it, in transit it should be supported, and that person shouldn't be forced to give it up, the data. Well, if we have all these safeguards in place, the use case where we send the data to an importer who is provided with sufficient legal protection to keep the data for him or herself, again, doctor, lawyer type of situation, then again, EDPB considers this a use case where you could actually send the data. The final one in there, the list of technical measures, where they provide us with a situation where they feel you have sufficient measures, is one that at least in my experience, I found difficult to find a practical application. Where they talk about a situation where we have two different processors in different third countries, and we split the data set that we want to send, and one party receives the data, another party receives the data, both of them receive pseudonymous data, so they can't identify anybody in their data sets, and then we have a process which they refer to as secure multi-party computation that allows us to still process this data in some way as the controller without any of those two parties having access to the data. It boils down to, bottom line, we send anonymous data sets to two parties who can't use them. In my experience, I'm not sure in which situation this is something that you would apply, but it's the final use case where they describe there. This is where we see sufficient safeguards if you apply these measures. Perhaps more interesting are use cases 6 and 7, where they discuss, well, this is something where we feel we can't provide you with effective technical measures. Use case 6 is where they talk about a cloud service provider who, when you transfer the data to that service provider, who needs access to provide you the service. So think of the Microsoft Teams, Google services, AWS. In most use cases where you want to use their services, well, they need access to the data in some way, some shape or form. And again, in these situations, that's where the EDPB said, well, we can't find any effective technical measures. Then they talked about the situation where there's a transfer between entities. So we are a multinational organization. One is based in Belgium or in the Netherlands, and they send data to India or to America, where we have legislation such as it is, and where there aren't sufficient guarantees. Well, again, a situation where they say, well, we can't think of anything where there are effective measures in this case. So especially use case 6 is where perhaps for some people the EDPB guidance was a bit disappointing, because they basically say, well, there is no way to do this in a fully compliant manner. Zooming in on the draft standard contractual clauses, so something that we hope they will replace the current SCCs, but will provide more guarantees and make our lives a bit easier. I remember that DJ Reinders, the relevant commissioner from the European Commission, said that we would have new SCCs in April. I was hoping that by the time of this webinar, they would be available, but well, so far I haven't seen them. There is, of course, 1 day left tomorrow, so we might be surprised. So far, it looks like they won't be there yet. But what we've seen in the draft SCCs, and then again, we've taken a look at the version with included comments by the EDPB and the EDPS. Well, what they mentioned in the relevant annex, part 3, where they talked about the measures that the organization should be taking, they include the fact that, well, when you use these SCCs and you include the security measures, you should be as concrete as possible. So some generic descriptions they detailed won't be enough. You will need to include concrete security measures that you take. It should be with relevant examples. what we see in their guidance is that they basically don't name exact examples of what the measure should be. They just give a number of items, subjects where in your SCCs you should be including the measures you take. They mention pseudonymization encryption. They mention ensuring the CIA confidentiality, integrity, availability of data by having resilient systems. In your measures, you should be taking a look at the ability to restore availability in case there is an incident, technical, physical, processes for testing. Some other aspects that they mentioned should be included in the measures you detail in your new SCCs, user identification, authorization, in what way will people have access to the data, physical security, event logging. So in essence, without going through the entire list, classical things that you'll see in information security, where I think the biggest change here is that they do mention specifically you should include the measures that you take. Not some generic description, basically as you see here, but concrete measures should be included in the annex that you use for your SCCs. But that's as concrete as they get. And again, that's why I summarized this part of the webinar as the more theoretical approach. Trying to look at a few more concrete examples, because we're still in a situation where it's a bit of a gray area. Nobody's entirely sure, well, what works, what doesn't work, because the use case 6 that we discussed, the classic cloud infrastructure, simply saying, well, we can't find a compliant solution, and then assuming that all data transfers will stop, that's not the way it works. So looking at a few practical examples that we've seen so far. So we had the AWS Conseil d'État case. We had an organization, Doctolib, that was managing appointment information for vaccinations. There were a number of complaints, organizations that said, well, they use AWS, they use an American organization, so based on Schrems II, that's not possible. Now, interesting in this case is that Doctolib really prepared some nice documentation explaining why they felt that the measure that they took were sufficient. What were the measures that they explained? First of all, they emphasized, and in the judgment it was also mentioned by the Conseil d'État, even though it's vaccine-related, COVID-related, this is not sensitive information in the sense of Article 9 of the GDPR. It is appointment information, but it doesn't include any medical information. So, data minimization principle applied, the data isn't sensitive. We applied a storage limitation aspect, so the data would only be stored there for 3 months. And there was even an option for the data subject, him or herself, to proactively go in there online and suppress the data, delete the data. So that was something that they, a bit of control that they offered to the data subject. As included in the measures was also an addendum with AWS, with Amazon, where they included, it was a bit of a letter where Amazon declared, well, regarding any type of government access, we will inform you when this happens. We will try to fight it as much as we can. Now, of course, this is only for what it's worth. If Amazon receives a national security letter, which also specifically states you're not allowed to inform anyone that you've received this letter, well, that's where it ends. But at least for as far as they can do it, they provided this addendum, which was taken into account by the Conseil d'État. They also applied some specific security measures in this case, where they said, in essence, when we mentioned encryption quite a bit in the use cases by the EDPB, and this is something that they applied as well. They said, well, we take our data, and then we have a third party, Atos in this case, which is a French organization. They encrypt the data, and then they send it to AWS. And we use a mechanism in AWS, which is called the bring your own key, which means we don't let Amazon generate the encryption keys. No, we take our own key and then we bring it to the Amazon environment, which provides additional safeguards. They used Atos at the third party to provide additional security. All of these measures combined meant in the preliminary ruling by the Conseil d'État, this might get some additional decisions, but for now they said, well, we've taken a look at these additional measures and they suffice. Transfer can continue. Interesting in the way that, as opposed to a number of other cases that we've seen now, the MailChimp case, the Bavarian Data Protection Authority published some information. It was also now available on the EDPB website, where they, based on a complaint by a data subject, so they received a complaint by someone who said, well, this organization is using MailChimp to send me emails. this is clearly non-compliant because it's an American organization. And the Bavarian DPA looked into this, contacted the organization, and they were informed that for 2 mailing campaigns, that organization had indeed used MailChimp. They hadn't performed any type of impact assessment. They very fast said to the Bavarian DPA, well, sorry, we weren't aware. We'll stop using MailChimp. And then that was it. So DPA published this. They said, well, we contacted them. We found out that they hadn't performed any impact assessment. So we decided that because MailChimp as an organization might be subject to the legislation that we talked about in Schrems II, and there were no supplementary measures applied, well, transfer can't continue. And the company needed to cease the use of MailChimp. Important here to note, because I've seen that in a number of cases, the next one as well, this organization didn't perform an impact assessment. They didn't try to take any additional measures. So what I want to mention here specifically is that the Bavarian DPA didn't say nobody in the EU can use MailChimp, but in this situation, again, case by case, where there are no additional safeguards, where there was no impact assessment performed at all, well, then you can't use an American provider, in this case, MailChimp. And that is something that I think is very important to emphasize, because we see that all the time, and you see media outlets saying, well, you can't use MailChimp. Not exactly. But if you do, you will need to do an impact assessment, take additional measures. The same thing goes for the Portuguese case that I mentioned, again, from 2 days ago. The Portuguese Data Protection Authority published their decision, which I couldn't find regarding the Bavarian one. It was much shorter, also on their website, because it was based on a complaint. Here there is a formal decision. The link is included in our source, in the notes that you'll find in the presentation later on. But so they had an entire decision where, first of all, they concluded, well, this situation involves special category of data, because the National Statistical Bureau in Portugal did a census. So they counted the population, they did it online, and I assume it wasn't specifically mentioned, but it also included something like the national number or some other, again, information that at least the Portuguese authority deemed sensitive. So here's a first big difference with the AWS case. They use Cloudflare. Cloudflare is a CDN, a content delivery network, or at least that's one of the things they offer, Cloudflare. It basically means if somebody's on their browser and they enter information, using Cloudflare, you will determine, well, which is the fastest way that we can send that information to the final recipient, in this case, the Portuguese Statistical Bureau. That's a service that Cloudflare offers. So it's a sort of a traffic optimization service. But Cloudflare is an American organization. They use their servers, which are spread over 100 countries, where the most of them do not have an adequacy decision. They use those servers to deliver most efficiently. And so the Portuguese authority decided, well, in essence, if we look at what this activity is, it is the potential of having sensitive information transferred through the Cloudflare network that they control over 100 countries where the data might end up. So which measure did you take? Because we sense there might be a problem. And in this case, it was clear that the DPIA that was performed didn't include this aspect. So the Portuguese Statistical Bureau did a DPIA, but only on the fact that they were doing a census and that they were doing it digitally. But it didn't include the specific aspect of, we will be using an American organization, Cloudflare, to do the content delivery. Following a DPIA, the CNPD, as is the name of the Portuguese authority, wasn't consulted, so they couldn't provide any relevant advice. And finally, they also found, the authority, that there are alternatives to Cloudflare if you want to apply this technology. And so here, the same basic case, you didn't have an assessment, you didn't have supplementary measures. What was even a bit more egregious here is that the DPA, the Data Protection Agreement with Cloudflare, specifically mentioned, by the way, Cloudflare may be subject to legislation that doesn't comply with your legislation regarding data protection. Just keep that in mind. And again, that was a standard DPA that they used. So given all this information, the Portuguese authority was quite strict. The Statistical Bureau had 12 hours to cease all use of Cloudflare. So, but again, keep in mind here, lack of accountability, lack of information, lack of transfer impact assessment. And I think that's the big difference here, that they didn't have any additional measures that they proposed. So here also, perhaps for Cloudflare might be difficult to use them in the European context, but at least if you would do it, you need to perform the assessment. You need to be able to show, well, which additional measures that we take. Taking a look at some concrete measures, some things that I've seen in practice where I feel that we have taken sufficient measures. We have something called on-device processing, something that I see more in the mobile app context, where you say, well, if we need to do some processing of data, even sensitive data, we make our app, our application in such a way that it happens on the device. So there is perhaps some sensitive data processed, there is a conclusion reached, and then aggregated, perhaps in a score or some final conclusion. We send the information onwards, but the actual processing of the data was done on device. And that means, in essence, that there will be no uniquely identifiable data or sensitive data sent onwards, perhaps to a third country. So the on-device processing is one way to apply supplementary measures that should suffice. End-to-end encryption, I think a pretty useful concept, and then often applied in even WhatsApp or Signal messaging apps. Basically means we have information, before we send it, it's encrypted. And the only one that can actually read the information is the recipient. So thinking back to the use case where you would send information through a third country, finally arriving within the European Union again, end-to-end encryption is a sufficient application of a measure that would be sufficient. Something, again, which is quite common these days, applied in many applications. Anonymization, it was already discussed in plenty of the use cases. If you anonymize data before sending it onwards, either by using a third party to help you anonymize it, there are these days organizations specialized in anonymizing data, or by doing aggregation, not sending the detailed information, but raising it to, instead of on a personal level, saying, well, in categories of people between 12 and 18 and 20 to 25, in such a way, aggregating the information. Anonymization, another measure that I've seen applied, which works for sending information onwards. Some other thing that I've seen in again, the mobile landscape is where they use software, SDKs as they're called, from an external provider. So you have your own app, you've made an app, it does whatever you want it to do, and then you can include a tiny piece of software, SDK, from an external provider, which helps you handle the encryption or anonymization before you send it onwards. So the big difference with the on-device processing here is that you don't need to do it yourself. You can include some software by a third-party provider that does it for you. That's another solution that I've seen applied. And finally, something that I think isn't considered often enough. Take, for example, MailChimp. I think what you could do there is switch to a EU provider. There are EU organizations that offer the same technology as, for example, MailChimp, newsletter campaigns. And of course, doing that assessment, is there any technology that we use that we might apply by using an EU-based solution provider? That is the best solution. And so I think it does make sense going over your technology stack, going over the different technical things that you use, and to find, is there an EU alternative, which avoids all the risk of an international data transfer altogether. Finishing off with the example response that I received from a US-based processor, where it isn't perfect, let me stress that, but from all the providers, including Google, AWS, many other organizations that we asked from our DPO perspective, provide us with the measures you've taken following Schrems II, I found this was one of the best responses that I got. So they started off with saying, well, we apply encryption addressed and in transit. Keep in mind that they didn't mention anything about who controls the keys. So this, again, wouldn't be perfect, but at least they mentioned, well, we apply encryption everywhere. We have never received any visa requests. The legislation which allows your intelligence agencies in the US to access data, well, they specifically mentioned we haven't received any so far. Looking at the visa legislation, we haven't found any court so far that said, well, our organization is subject to it. Again, here as well, no court has found that we are subject to it. Well, there isn't a court that does that until there is one, until there is a case where they are found to be subject to that legislation. But again, they can't do any more than say, so far, we're clean. When we receive any type of bulk surveillance request, we will fully ignore it. We will, whenever we would receive any request for disclosing information, we guarantee you that we will fight it as much as we can. They publish transparency reports. And they mentioned, well, every 6 months we will also transparently report on any type of access requests that we've had. And should anything happen proactively before we need to hand over the data, we will let you know, at least. So we won't know for sure until we're actually in a situation where we have a data protection authority, we have a court case where we need to defend based on the measure that we have here. But taking some measures mentioned by this processor and some of the measures that we saw before that you could take as a controller, I think you would have a very good case in defending, well, we've taken enough additional supplementary measures to provide a sufficient level of protection. So again, so to just provide you with some examples of what we've seen in practice that are a bit more practical than what you've seen in the EDPB guidance so far. A few final notes that I'd like to make based on my experience so far with performing transfer impact assessments and looking at the different cases. Accountability can't be overestimated. All the cases so far that we've seen where a court ruled you can't continue your transfer, it was always the same case. They hadn't looked at it, there was a lack of accountability, they had no assessment that they could provide to the authority or to the court, and that's a huge difference. And that's, again, this risk-based approach by performing transfer impact assessments that will help you if you were ever challenged in court or with the Data Protection Authority to show that you have taken the supplementary measures, documenting it. There's a theme in these recent cases where the ones that can't show anything get an order to seize the transfer, and the only one we've seen at the Conseil d'Etat where they could provide with a list of measures was ruled that they could continue the transfer. Also keep in mind that the new standard contractual clauses won't be the silver bullet of international transfers. It doesn't mean that impact assessment, transfer impact assessments will cease. This is something that I think wasn't highlighted enough, but in the joint opinion by the EDPS and the EDPB, they specifically mentioned there will still be cases where if you use the new SCCs, you will still need to show that you've taken supplementary measures which help you provide enough protection. Even though you use an organization that has applied the new SCCs, you may still need to have supplementary measures in place. So something to keep in mind. We've been doing quite a few transfer impact assessments at our clients in the past time, and that's not something that's going to go away. That practice will remain, assessing the transfers to third countries. To finish off, free webinar, tiny bit of commercialism. I'd like to stress that we have some really interesting new trainings coming up. If you found this a useful webinar, we have a bunch of trainings that I think you might find useful as well. One is coming up in the beginning of June, IT security for legal professionals, where me and probably a colleague will help legal professionals understand the more technical terms a bit more. So we look into things like encryption, software development, cloud applications, and will help legal professionals get to grips with the more technical terms. These trainings are, by the way, physical. They're in a classroom in the hotel. All COVID measures applied, but so I'm really looking forward to having some real contact again. Another training is the DPO expert update, where we look into executing DPIAs, international transfers, lessons that we've learned from DPA decisions, and look into the details of pseudonymization and anonymization, techniques to apply it when it doesn't work. And finally, our DPO certificate training, starting the 7th of June, where we train new DPOs, including an exam, giving them all the knowledge they need to be a DPO in practice. So thank you for that attention for that short update on our trainings. And I would like to take a look at Geoffrey, going into a bit of Q&A.
Yep.
We have some time left. Which questions were asked?
First of all, thank you very much, Bart. I hope all of you enjoyed this amazing presentation, of course, here. But yeah, no, Bart will answer some questions. I noted several interesting questions here. Maybe, yeah, first one to start, and maybe it's also very straightforward, maybe not. There was a question there. Is it correct that the usage of US tech giant solutions is not compliant in global companies? So, yeah, is there any straightforward answer to this?
Yes, in essence, you saw the use case 6 that the European Data Protection Board discussed.
Yeah.
They basically said in those classic cloud solutions where the US provider has access to the data, so
Yes.
Microsoft Teams, Google Drive, without any additional measures, these are non-compliant.
Okay.
Which of course, business-wise is a challenge because as I mentioned before, these transfers won't suddenly stop. People won't suddenly stop using them,
No.
but they did say, well, we can't see any supplementary measures that you can take at this point. And so officially, these are now non-compliant solutions.
Okay, thank you. And next question, maybe a more technical one here is what does it actually mean, transfer through third countries? From a technical perspective, what does it mean?
It means that you have information. Take the Statistical Bureau in Portugal as an example.
Okay.
You have them having a website where Portuguese citizens fill in a form that they send it. Then before it is actually received by the Statistical Bureau themselves, it is sent through the Cloudflare network. And that means that they can have a server in, just say anything, Liberia, in South America. The data is sent there, but it doesn't stay there. It will only be stored in transit while it goes through the server and then sent back to Portugal. So that's what they mean from a technical perspective when they say it goes through a third country. It isn't actually stored there for anything longer than a number of milliseconds, but it does pass through, going through its final destination. Right. So the Cloudflare, the use of anything that helps optimize network traffic, that's an example of where the data passes through a third country but doesn't actually stay there.
Okay, thank you. Then another question, also a statement of someone. Someone mentioned here in the chat box, a UK bank stated that pseudonymized data sent to a SaaS provider does not constitute personal data. What's your opinion on this one?
I agree. And it was also one of the use cases that the EDPB mentioned in their guidance. Okay. They did include a whole bunch of measures because in essence, what you say when you have pseudonymized data, you say, well, we have a data set, we remove all the information that might make it uniquely identifiable, and we keep that information somewhere. So we still have the information you would need to identify people, and that's why it isn't anonymous, because if it's anonymous, then you have a data set, and no matter what you do, no matter which extra data you add, you can't go to a unique individual. Now, in this case, you say, well, we still have that data set. It's still there somewhere, so this data is only pseudonymous. Now, if you then send that pseudonymous data set to a third party, and you ensure, you're absolutely confident that they will never access that additional data, then you can send it onwards, and then, in essence, that data that you sent is anonymous. Because the only way that you could go back to an individual is if you have the data that you have really, really secured. Now, that's what they mentioned also in their use case. You need to have absolute guarantees that this additional information isn't available to anyone else. Given that situation, then you can, in fact, say if we send pseudonymous data onwards, then the data that we send for that third party isn't personal data. That's basically what that bank, I think, is saying here.
So that's more or less a pragmatic approach that they...
Yeah, I think so. And then, of course, what would happen if this was taken to court is that by documenting the measures you've taken to make sure that this additional information isn't available to that third party, and that information isn't available anywhere else, so that you can basically guarantee the data that we sent on is anonymous. That's a case where this might work.
Okay, perfect. Okay, Bart, thank you for answering these questions. The questions you didn't answer, we will definitely answer them via email. If you need any support with regard to international data transfer impact assessments, Bart and I, you can also reach out to Bart or to me. And I think we can conclude the webinar here. So thank you all for attending, and we hope you have enjoyed this presentation.
Okay.
Thank you.
Rest assured, we will send the slides to everyone attending. They will be available. Yeah. And again, as Jeffrey said, by the way, thanks for moderating the webinar.
You're welcome.
If you have any questions, contact us and we'll try to pick them up. So, thank you very much, everyone.
Thank you all.